All right, the first of a few experts on the stand. We need to slip in a break here. Before we do, let's check in with National Trial Attorney Michael Jaafar. Big case, Mike. He's right here with us in studio. This case has a lot of attention. A lot of our viewers are watching it, and there are people on both sides. This is pretty clear. This young woman killed her mother in a brutal fashion. So, a lot of people believe that what the good doctor's talking about now is that she was suffering from this. Where do you stand on it? What do you think is going to happen here? And where's the law stand on it?
You know, the seminal case in Ohio on this topic is a gentleman who dressed head to toe in ninja gear and regalia, broke into his friend's house and murdered his friend with katana blades. And other of his friends were there trying to stop him. He didn't hurt them. He just kept killing and stabbing his friend because in his mind, he was on a crusade to stop his friend from harming society. He truly believed this. Now, the facts are bizarre, right? But the ruling is even more bizarre. And this is where the law stands in Ohio. The jury convicted him, even though he had already had a diagnosed disease of schizophrenia. He was diagnosed for it. The reason they convicted him was because even in his mind, in his ninja, bizarre world, he knew he was doing something wrong, right? So the way that the jury looked at it in Ohio is, even if you are far off and you're in bizarre world, if you think you're doing something wrong, we're still going to convict you. So the chances of her being acquitted of this, I would say, are very slim.
Because clearly she knew she was doing something wrong. She covered it up. She lied, got on the phone, broke the glass. All of that is pretty clear. All right, let's get a break in here. We'll get you back into the courtroom for more of Dr. Reardon. Right. Michael Jaafar, this doctor seems like he has a very good understanding of Sydney. You know, a lot of times an expert will just look at charts. He's interacted with her. He's diagnosed her. So let's say I believe everything the doctor is saying. Yes, this kid had schizophrenia, X, Y, all of it. I believe it all. Does that mean I find her not guilty?
No, because there has to be a couple of leaps. And first of all, just to your point, if you notice, when he's in the courtroom, she's very calm. All the other times that she's been in the courtroom with any other witness, she's been breaking down, she's been crying, she's been in pieces. She's been basically a puddle of water in the courtroom with every other witness until he came on. When he came on, she calmed down, her demeanor changed. For him to make this analysis, he must have spent hours upon hours upon hours with her on multiple days, right? So if you believe every single thing that he's saying and you're a juror, you still, when you go into that jury box, you're going to say, okay, so there was one expert that said she was fine. Another witness, another expert said not only was she having a schizophrenic breakdown, but when they asked him why, well, then why did she lie to the police? He said, well, she didn't know she was lying. She said, well, how do you know? He said, well, lying means when you tell somebody something, you know it's not true when you say it. She didn't think that she was lying. And so if you're a juror, when you go into that box and you say, even if I take it as a matter of fact that she was schizophrenic at the time, she still knew what she was doing was wrong because of her actions after the fact. That's what happens in these cases. They always look at jurors look at your conduct after the fact. I don't necessarily agree that that's the right thing to do, but they always look at your conduct after the fact, so the answer to your question is I don't believe that would be enough for the jury.
We need a break. Chanley Painter is going to join us after the break here.
So the witness needs to run to the restroom. I don't blame him. He's been talking for a long time, Ted. In the meantime, I know that we have in studio there National Trial Attorney Michael Jaafar with us. Let's take a moment to talk about what we've been hearing and seeing. But I want to start with what I mentioned to you earlier, Ted, is that there is a packed courthouse inside, packed courtroom inside this courthouse behind me. Sydney Powell just walked by, actually. I know we're behind on, because we are bringing everything to our viewers, but I just wanted to mention Sydney Powell and her attorney just walked by for the lunch break. So, but her family and friends there, Michael, that is strategic for this defense, and they didn't show up until her case began making a statement, right?
Absolutely, because I mean you're in the courtroom, so you know how emotional it is. These courtrooms look bigger on TV than they actually are. They're actually very, very, very small. They're very intimate. Everybody is within an earshot of one another, and so having your family there to show support, and you're a juror, you feel like you're part of the family. You feel like you're seeing the family unit in place. She's got her family there. She's there. I mean, the whole thing is a big difference. These jurors are human beings. And when they go into that box, they have to make a human decision. They have to decide whether to put somebody away for life in a regular prison, or there's no acquittal for her here. The other option is to basically commit her to getting medical treatment for the maximum amount of time that she would have been in jail. So either way, these jurors have a very morbid decision.
Absolutely.
Let's bring in, of course, National Trial Attorney Michael Jaafar. And Michael, what do you expect to see and hear from prosecutors when they pick up a cross of this doctor?
They're going to ask him how many hours he spent with her, what system he went through, how much he's been paid by the defense, how often has he ever testified against the defense, you know, how many times have you testified for the defense, and in those times, how many times have you said something different than what you said today. So they're going to try to undermine his credibility. At the end of the day, everybody's job, you know, the defense's job is to make sure that the jury goes into the box with one overwhelming feeling, and that's doubt. Right? And so the prosecutors want to make sure there's no doubt that she is culpable, she did this and she knew what she was doing. So they're going to undermine his credibility. It's going to be difficult. The guy comes off very credible. He comes off very sincere. So that the prosecution, you know, they can ask leading questions. They can come in and they will ask them the battery of questions that they ask every single expert witness, which is, how much are you paid? How often do you do this? Have you ever said anything other than something that helped the defense? Because they want the jury to know, hey, don't listen to this guy. He's supposed to say this, but you know the truth, jury. You know, go in there and just take what he's saying with a grain of salt.
How much of an advantage is it to take the lunch break? Because with expert testimony, of course, you can have your expert in the courtroom to listen to the other expert. Now they've got an hour to prep, and they know what their guy's going to say, guy or girl, right, when they have their rebuttal case. It'll be targeted. Michael.
I completely agree. I mean, at the end of the day, it's gonna be like a quick shot, you know, cross-examination. They don't have time to prepare, but they kind of know what they're gonna ask. They ask the same battery of questions of every single expert witness, and as we know, this whole case is gonna come down to the expert witnesses. Everybody knows she did it. She's admitting she did it. Everybody knows where she was, and so it just comes down to the experts. What I've noticed is, you know, as I've told some of my friends, when that doctor was in the courtroom and her family's in the courtroom, she had a different demeanor. She was very calm. She was very relaxed. Yeah. You could tell this person has treated her for many, many months. He has spent at least 30, 40, 50 hours of FaceTime with her. So the prosecution has not spent time with him. They're going to have to cross-examine him. And we kind of know what they're going to do.
Yeah, Michael, you bring up a great point. Her demeanor a bit different today. She was excused for much of the prosecution's case in chief at no objection from prosecutors. And now she's sitting in there for her defense as her witnesses testify, making a statement there for that. And you also bring up another great point, is that the expert we expect in rebuttal, according to the defense team, didn't even sit down and meet with Sydney and evaluate her in person. That's going to be a big point in favor of the defense, is it not?
100%, completely agree. You know, because how are you going to diagnose somebody or opine on somebody's catatonic state, what they believe, what their impression in their mind was, if you haven't spent the kind of time with that person? Look, my personal opinion from seeing this expert and seeing the testimony and the evidence, my personal feeling is that she was in a catatonic state and she had a schizophrenic attack. This expert has convinced me, because there's no other explanation, right? And so, you know, you could see the writing on the wall, but whether or not this jury will take the leap of saying, okay, she had a schizophrenic attack, and oh, by the way, in addition to that, she did not appreciate the wrongfulness of what she did. I doubt that the jury will do that, because having schizophrenia is not a defense to murder. It's just an explanation as to why you may not have appreciated the wrongfulness of what you've done.
Michael Jaafar, great to have you here with us for this hour. You're going to be along on Court TV in subsequent hours. For the rest of the day, Chanley, the lunch break's almost over. You haven't had your lunch, so you better scurry and get into that courtroom, and you'll be with us as well throughout the day.
Yep, that's right, Ted. We're going to be inside the courtroom. We're expecting this expert's testimony. And like I said, this is one of a couple of more we'll actually be hearing from the defense, plus another lay witness, a teacher of Sydney. So a lot more to come for this defense case.
All right, Chanley, Michael, thank you. We'll get a break in here. And
all right, we're going to hit the pause button. We're going to get to a break soon, but I do want to welcome in my guest for this hour, national trial attorney Michael Jaafar, who is here in studio with us. Michael, thanks so much for being with us. We're listening to this defense expert, and it seems that the state really wants to make a big point of the difference between delusions that point to schizophrenia and this anxiousness that the defense is saying points to schizophrenia. What's your take on how the prosecution is doing with this cross-examination?
I don't think they're doing a good job because it almost doesn't matter what leads to schizophrenia. This is around the age when schizophrenia starts to set in for a human being, right? And so all that matters is what her state of mind was during the act. And neither the prosecution, neither the police, nobody was there except for the defendant. And so the person who's kind of peered into it as much as possible is her doctor. Her doctor, I mean, we all take our doctor's advice. Imagine sitting down with a doctor for any type of ailment for years, and he analyzes you for years. Who's going to know more about your ailment than your doctor? The prosecution is not going to know about it, and some of the witnesses they're putting on and the way they're cross-examining this witness, they're not doing a good job because he clearly knows more about her state of mind more than anybody except for her, right? And so the jury's going to have to determine his credibility, and I don't think they're undermining his credibility.
Yeah, we'll have to see who the defense calls next in terms of their 3 medical experts that they are planning to call in this case. We're going to get to that break, but still ahead, we're going to hear the assessment of this defendant that happened 3 or 4 days after the murder. That's coming up next. Don't go anywhere. All right, we're hitting the pause button there inside of the courtroom. I want to bring in national trial attorney Michael Jaafar, who's here in studio with us. Michael, you've had so many things that we've been talking about while we're watching this trial together, specific to schizophrenia, specific to not guilty by reason of insanity cases. What are your thoughts on what we're seeing so far and what this jury might do with this case?
I think, you know, when we watch expert testimony, we're trying to see if we're convinced by what they're saying. I'm convinced. Me personally, I'm convinced that this girl was dealing with a schizophrenic episode and she may not have appreciated the wrongfulness of what she's doing. But I'm somebody who's observed these cases, I've studied these cases, I've looked at these cases. I'm hoping the jury's the same. I want to see what the rest of the experts say. The fact that this, forensic expert didn't start treating her until 20 months, pretty much 2 years after the event you informed me. That could harm them, but as I sit right now, I'm convinced that she was dealing with a schizophrenic episode and she could not appreciate what she was doing or maybe even knew what she was doing in her normal state. Right now, I'm convinced.
Now, you made a differentiation there, and I want to highlight that for our viewers. If this jury believes she's schizophrenic, does that mean she's not guilty by reason of insanity?
Great point. So schizophrenia obviously is not a defense to murder, right? So even if the jury believes that she was schizophrenic, they have to then take another leap. So there's the first leap. The first leap is to believe she was schizophrenic and not just doing something rotten, she's not just the villain. Once they make that leap, if they do make that leap, and I don't see how they don't, they have to then make a further leap to say, well, okay, as a schizophrenic person, she did something she did not appreciate the wrongfulness of it because the laws in Ohio are very bizarre and they're based on a case that went all the way up to the Ohio Supreme Court where the facts were even more bizarre than this, but the Supreme Court said, you know, hey, this person was schizophrenic, he was diagnosed schizophrenic, but he still knew he was doing something wrong when he did it. So I don't know about that.
So good to have your insight. I know you have several offices in Ohio, so it's good to have your expertise on Ohio law. We do have to get to a break, but we're going to get you right back inside of that Ohio courtroom in just a moment. Let's bring in national trial attorney Michael Jaafar. Michael, malingering, we're hearing that term. How does a doctor determine if someone is trying to play up their injuries?
So the doctor's going to have to spend dozens upon dozens of hours with every victim, with every patient, to be able to make an informed decision on whether or not they were malingering, whether or not they were in catatonia. There's so many conclusions that this doctor's going to have to make, and the jury is eating out, like not eating out of his hands. They're like hanging on every word he says, because when they go into that box, this is going to just be the battle of the experts. So whatever this, they're going to look at the credibility of every expert, and they're going to make their decision based on the relative, credibility of all the experts. So the way he's going to define it is by in showing how much time he has spent with this victim so he can be credible. If he says, I spent 10 minutes with her, they're not going to believe anything he says. Hey, I spent 10 minutes with her. I spent 30 minutes with her, right? Or I spent 20 hours. I spent 2 months, 6 months. So that's really how the expert is going to make that determination.
Timing is important. That's probably why the prosecution wanted to highlight in their cross-examination that he actually didn't start treating her until 20 months after. But the defense has several other witnesses that they're going to call that are experts. Perhaps we will hear from one that treated her during that gap after this tragic killing. Michael Jaafar, thanks so much for joining us in studio this hour.